All right. All right. Good evening. Welcome. Apologize for the delay. It's been one of those crazy days, but I will also, by the way, welcome Professor Guerra Pujol, and welcome. This is the last lab or the last class in legal and ethical environment of business. We only had 5 labs, 5 classes, and what we did is address a different aspect of the legal environment of business in each of these 5 classes. And I have, for those of you enrolled in the course, I've created a module for each of the classes. Everything that I talk about in today's class will be in the module. If you want to, further explore and, look at the details, I'll show some of the things in the module as well as time permits. I posted on in the chat and on the course homepage 2 important links. One is going to be the link for if you haven't done so already, the survey, the in-class activity, I should say, which is a survey for this particular class. So it'll be your, and then the last, graded survey in this course. And also I posted a link to an extra credit survey to get your feedback on the decision by Florida Board of Governors and the University of Central Florida and other public universities to essentially ban TikTok and WeChat and other foreign-owned social media platforms off of campus. And what I'll do is, today I'm going to do things a little bit differently. I've prepared a short slide presentation so I can, we're here going to really combine 2 big topics: corporate governance and business ethics. So I thought, let's do a slide presentation where I can fill you in on some of the big picture things. And then at the end of class, if you stick around, we'll go ahead and quickly look at the survey results. Normally what I've been doing is using the survey results as a kind of slide presentation. But here I thought a lot of little details I want to cover. So I'll do a screen share and I'll just pull up the slides now. Let me just, I do have them ready here to go. Let me just find screen share. Okay, here we go. All right. And why don't we take this from the top? Let me see here. We'll do a slideshow. All right, I think now everything is good to go. We've got our presentation up and running. So let's just jump in then without further ado. This class should be about an hour, although I've scheduled an hour and a half. If anybody has any questions, comments, or concerns, et cetera. All right, so I'll jump in here. Let's see if this is working. All right, here we go. So let's talk first about corporate governance, just the different ways of doing business. Now, one thing I'll say, I've noticed from previous semesters, many students in the class already well aware of the main forms of doing business and are pretty savvy about the advantages and disadvantages. So I'm just going to do a sort of a brief rundown here and then focus on one aspect of corporate governance that you may not be so familiar with. So let's do the stuff that you may or may not be familiar with, just the main forms of doing business. And by the way, in this respect, the movie The Social Network, which is about the founding of Meta Platforms Inc., or back then it was called Facebook, it's really instructive in this regard. In many ways, Zuckerberg, before he teams up with Eduardo Saverin, with his best friend, you could consider him a sole proprietor. And a sole proprietor is just basically when you own and operate your own business, without any formal legal formalities. It turns out, by the way, and again, I'm surprised how many of my students are already aware of this, but I'll just put it on the record. Most business entities in the world and in the United States, when I say most, I mean more than 95% are in fact sole proprietorships. Now, the thing about partnerships, especially general partnerships, there's also something called limited partnerships, but a general partnership is basically when friends just go, 2 or more people, usually friends or family members, go into business together. There may or may not be a partnership agreement in writing, But the partnership agreement, whether it's, an informal one like the one Eduardo and Mark Zuckerberg had, or a more formal one that's put down in writing, that's another form of doing business, goes all the way back to ancient Rome. The partnership, or the Romans would call it the societas, the society, is the oldest form of doing business. The thing is, you'll notice I have both of these forms of doing business here on the left side of my chart, of my visualization, because they both have a serious disadvantage, and that is that the owner, the sole proprietor, if it's a one-man, one-person show, or the partners, in the case of a partnership, the general partners, they are all personally on the hook. They are all personally responsible for all the debts, obligations, contractual contracts, and legal liabilities, generally speaking, of their business entities. And in the case of a partnership, the fellow general partners are actually also responsible for all the legal liabilities incurred by their fellow partners in the course of doing business. And so you can imagine Eduardo, becomes partners with Mark Zuckerberg. And in the movie, when they launched the Facebook back in February of 2004, offhand, Eduardo, played by Andrew Garfield, great performance, by the way, notices there's a demand letter. And I showed you a photocopy of it in the previous module, a demand letter from the Winklevoss twins threatening to sue Mark Zuckerberg. And the thing is, Eduardo, as Zuckerberg's partner, even though Eduardo really had nothing to do with stealing the idea and building Facebook, but as his partner, Eduardo is just as legally liable for, any potential, judgment or verdict against Zuckerberg, against the partnership, as Mr. Zuckerberg himself would be. And if you paid close attention to the movie, this is true in real life. Eduardo actually was not only the president of the finance club at Harvard at the time, he was also a very wealthy college student. He had invested in oil futures the previous summer of 2003 in the Brazilian oil market, and had made a killing, several $100,000 that Eduardo has in his bank account. So, Eduardo's looking at a potential, a quagmire here. And this is where we go to the left side. And one of the things you see, I've included it in the modules. I've included the articles of organization of the Facebook limited liability company. One of the first things Eduardo does after he invests in the Facebook, gives Zuckerberg the mailing list of the Phoenix Club, and is he registers the Facebook as a limited liability company in the state of Florida. If you want to see the articles of organization for yourself, they're right there in the modules. You'll see a copy of it. It's a one-page document, and the main advantage of a limited liability company is that while you're always exposed to whatever you invested in the company, but now you're no longer personally on the hook. It's the company that's on the hook, generally speaking. And then the last major form of doing business is the corporation, or the corporate entity. The main difference between a corporate and corporations, like limited liability companies, the owners enjoy limited legal liability. That's the whole advantage there. The main difference between a corporation and an LLC is that in a corporation, right, corporation can issue shares, right? It can issue shares. Limited liability companies do not issue shares. A limited liability company is basically like a partnership, but reorganized as a limited liability company. One of the other advantages of a limited liability company and of a corporation is if you're a sole proprietor and you don't have any partners, you could re-register as a single member LLC or as a single shareholder corporation. And that way you can still conduct your business, but enjoy the benefits of limited legal liability. The main difference, though, between an LLC and a corporation is that an LLC, as you can see the module, I've included, by the way, both the articles of the original articles of organization of the Facebook LLC from April of 2004. And then I've included Facebook's, now they're called Meta Platforms Inc., but I've included their articles of incorporation and bylaws and shareholder agreements when Facebook became a corporation. And so with a corporation, you got to file a lot more documents. You got to file, you have to draft bylaws. You have to have regularly scheduled meetings. You have to have articles of incorporation that are fairly detailed. And generally speaking, there's more than one shareholder. You're going to have a shareholder agreement. With a limited liability company, it's much more simpler. It's just a one-page filing, like the one for the Facebook that I have in the module. Just a one-page filing. Very simple. Now, if the limited liability company has 2 or more members, the LLC should also have in place an operating agreement. The operating agreement, you don't register that, you don't file that, but there should be an operating agreement. And what the operating agreement does is it kind of like a shareholder agreement in the case of a corporation. What it does is it specifies what happens in the future if, for example, one of the owners wants to sell their shares. Can they sell their shares to anybody, or are they restricted in who they can sell their shares if it's a corporation? Or if it's an LLC and you have, like, let's say 2 members, or like in the case of Facebook, you had Zuckerberg is listed as a member, Eduardo is listed as a member, and a fellow Floridian, Dustin Moskovitz from Ocala, Florida, is listed as the 3rd member or owner of the LLC. So the reason why an operating agreement is so essential is because, okay, for example, how are those votes weighted? Is it one man, one vote? You know what I mean? Or because, Zuckerberg has, like the largest stake in the company, 70%, or actually he took it down to 65%, gave 5% to Dustin Moskovitz, and the other 30% went to Eduardo. Will their votes be weighted in the same fashion? So that you can decide what to do in the operating agreement. Now, it gets more detailed. The main point I want to emphasize here is that whatever business entity, one chooses, however a company, a business, whatever its legal format or legal model is, it's going to always be a creature of state law. So if you're a sole proprietor or a partnership, you are considered an entity in the state in which the sole proprietor lives and does business, or in which most of the partners live and do business. If you're a corporation or LLC, you're considered a creature of the state in which you registered. So that's one of the unique things about corporate law, that it's mostly 99% state law. The only real time federal law will come into play is if you're in a regulated industry. Let's say you set up a company, aviation, then you're going to be regulated by the FAA, or you set up a company to sell food products, you're going to be regulated by the FDA, that kind of thing. Also, if you're a publicly traded corporation, right, then you have a lot of disclosure requirements. You're going to have to file basically what's called a 10K, an annual report, with the SEC, Securities and Exchange Commission, every year, in addition to whatever you have to file with the state. And you're going to have to file quarterly reports as well. And so that takes me to the next point. There are 2 really main types of corporations. Most corporations are what we call privately owned or privately held, or closed corporations. Only a small number of shareholders, usually friends or family members, and there's usually restrictions on who you can sell your shares to. But a small number of corporations are publicly traded corporations whose shares are listed on the big board, the NASDAQ, for example, or the New York Stock Exchange, or the Nikkei index in Japan, Tokyo, or the Bourse in Paris, whatever, and it's those publicly traded companies that have those, additional disclosure requirements. For example, SpaceX, and I'm surprised, most of my students know this from previous surveys. SpaceX is a privately held company. So Elon Musk doesn't have to make these annual disclosures. But Tesla, for example, is a publicly traded company. So is Twitter. So those 2 companies do have to make these annual and quarterly disclosures, under the SEC Acts of 1933, 1934. I'm not going to go into any further detail there. In my advanced topics class in the fall, I delve more into detail into the regulation of these disclosure requirements and of publicly traded corporations. But the reality is, publicly traded corporations, just a small handful, just a few thousand in the world, whereas most private business entities are going to be either privately held corporations or limited liability companies, or general or limited partnerships, or most businesses are actually sole proprietors. So now the main advantages and disadvantages. You have sort of a big picture of the different forms of doing business. Because this is a survey course, I don't want to go into further detail. Before, when we had lecture capture, we would have regularly scheduled lectures. I would go into great detail into each. I would have a lecture actually for each one of these business entities. Today, though, what I want to do is share with you something that you perhaps don't know, and that is the fact that most of the publicly traded companies, the biggest companies in the world, Fortune 500 and publicly traded companies, are in fact registered in Delaware. You are a creature of the state in which you register. So if you decide, to enjoy, if the owners decide they want limited legal liability protection, which of course is something that's important, right? You have to pick a state in which to register, just one state. You have to pick one card, only one card. Most people, right, will just pick the state in which they live or do business, right? If it's a small company. But it turns out the big companies, for some reason, over 2/3 of them prefer Delaware. And here's just an example. Here's a graphic, of some of the big companies in just a wide variety of industries, whether it's automotive industry, banking industry, fast food and beverage industry, insurance, luxury goods, entertainment, technology stocks. A lot of, you can see right there for yourself, all of these companies, and Facebook, Meta Inc. is no exception, even though their headquarters are in, Menlo Park, one hacker away, you know what I mean? They're registered in Delaware. And the same goes for like Ford Motor Company, right? They have their headquarters in Detroit, but they're registered in Delaware. All of these companies, and this is just a small sample, but these are some of the most famous companies, in the world, are registered in Delaware. FedEx, right? Nashville, Tennessee, big company, but they're, from headquarters and originally in Nashville, but they're registered in Delaware. Could go on and on, right? So what is it about Delaware, right? What is it about Delaware that, attracts so many large companies? Well, I'm going to cut to the chase, and I'm going to give you an example that you may be familiar with. You may remember one of my initial surveys in the class was, what social media platform do you use the most, or do you prefer the most? And Twitter got a respectable number of votes. I think Instagram got like 40%, Snap and TikTok came in, like YouTube were in the around 25 to 30%, and Twitter was right there, right behind them, And you may recall, here's a timeline, right? Elon Musk, last year, right? He decides he's going to buy Twitter. And there's a board of directors decides, after initially kind of resisting, they decide that they're going to go ahead and sell, to consummate the deal with Elon Musk and his group, his investment group. But then in July of last year, about 9 months ago, Elon Musk decides he's going to back out of the deal, right? And you may remember had this excuse that the board of directors of Twitter misrepresented the number of bots or, fake accounts on Twitter. How many Twitter accounts, by the way, same problem on Facebook. They're actually, and this is actually quite controversial, Facebook hasn't been fully transparent about this, neither has Twitter. How many Facebook accounts are, genuine real people, individuals, and how many are just fake, spam bot accounts, you know what I mean? And so he decides to back out of the deal. And in July, Twitter decides to sue Elon Musk to compel him, right, to either pay the liquidated damages that was in the, merger agreement, the acquisition, I should say, agreement, a $1 billion liquidated damage clause. And by the way, a lot of contracts have liquidated damages clause, that is to say, if there's a breach of contract, this is the amount you're going to pay as a penalty, and Elon Musk decided, no, I don't want to pay the $1 billion, and so they take him to court, and guess what? The trial was scheduled for October. I mean, that's pretty fast. Or you may be following in the news, the Dominion Dominion Inc. is a company that makes these electronic voting machines. They're suing Fox News for libel for a bunch of new disparaging news stories from 2021, and that's set for trial now in April. I showed you the docket, of the ConnectU versus Facebook case, right? And you saw that case, it began in 2004, didn't really end until like 8 years later, right? Look at the Twitter case, right? That case was scheduled for trial in just a few months. Look at the the Dominion versus Fox News case. That case basically in 2 years, and it's already set for trial. And actually less because the lawsuit was brought last year. So really, what I'm trying to say is a lot of companies prefer Delaware, want to register in Delaware, because the Delaware courts, even though it's a small state, the Delaware courts, and the courts are called the courts of chancery. Something goes back to England, the name, but these courts are super professional, because they have so many big companies registered in Delaware. A lot of these lawsuits are brought in Delaware, so they have experience with big money cases involving the biggest companies you've ever heard of. And these judges, they're called chancellors, the judges of the Chancery Court, they run a super tight ship. They're super professional, super knowledgeable. I'll tell you, when I was at Yale Law School and I took business organizations with Judge Winter, a judge from the Second Circuit, which encompasses New York, Connecticut, and I believe Rhode Island. Most of the cases that he assigned, and when I say most, I mean 90%, were from Delaware. That's how influential Delaware law is, and and businesses love the fact that this is a very efficient court system. And furthermore, the Delaware courts have developed a body of law, a doctrine called the business judgment rule. And this business judgment rule is super, super important, if you're a corporation. Because here's the thing, right? Let's go back to Mark Zuckerberg. You may remember about like 15 months ago, he decided he's going to rename the company Meta Platforms Inc., and he's going to invest all of these, not hundreds of millions, not billions, tens of billions of dollars to develop something he calls the metaverse, and maybe some of you have been following the metaverse, right? But what happened? What happened when Mark Zuckerberg made that decision about 15 months ago? The stock price of Facebook tanked, and it tanked dramatically. And so this happens, sometimes a business, a board of directors, a CEO will make a bad business decision. And if the value of the stock tumbles, on the stock market, right, they might be sued for what's called breach of fiduciary duty. If you recall from my previous slide, I said all of these type of business entities, whether you're a publicly traded corporation or a sole proprietor, you're all a creature of state law. And in each one of these cases, the business owner, or in the case of a corporation, which separates ownership and management, the management team, they have a common law fiduciary duty to always act in the best interest of the corporation. So what happens when the company makes a bad business decision, and decides to, for example, invest in the metaverse, or Disney decide to pick a fight with Governor DeSantis, whatever, and then the stock starts to tumble, right? The shareholders are going to be understandably upset, and they might sue the company for a breach of fiduciary duty. But if it's a Delaware corporation, not only are you going to get the benefit of a pretty fast and efficient court system, but you're going to get the benefit of the business judgment rule. And here's the thing, if you're a Delaware corporation, even if you're sued in a different state, that other state is compelled to apply Delaware law to a Delaware corporation or a Delaware LLC. And what the business judgment rule is, in plain English, this is like the fancy language, like from the jury instructions a judge would give to a jury, in deciding whether a fiduciary duty was breached or not. But in plain English, what it means is that the Delaware courts don't want juries or judges second guessing business decisions. But just to restate what's on the slide, if the business, the board of directors or the CEO, if they acted in good faith, If they consulted all the relevant information, which is what we mean by acting prudently, you consulted all relevant information at the time you made a decision, and you thought reasonably it was in the best interest of the company. And the reasonable standard, as we saw from Oliver Wendell Holmes, is an objective test. What would an ordinary average business person, would they have made a same or similar decision? Then it's okay. And in fact, Delaware goes a step further. They presume that when a CEO makes a decision, even if it turns out to be a bad one, that he is acting or she is acting in good faith. That in fact, they consulted all the relevant information, and that, it was a reasonable decision under the objective test, that another business person, with the same information could have made the same decision, So it's up to the shareholder. When you sue a Delaware corporation or Delaware LLC for breach of fiduciary duty, alleging that that the people making decisions on behalf of the company made a bad decision that caused the company's stock to tank, it's up to you to prove that Zuckerberg acted in bad faith when he decided to invest all that money in the metaverse, that Zuckerberg did not consult all the relevant information, at his disposal at the time, and that's not the kind of a decision that a reasonable business person would have made. But think about it, right? Think about how popular Roblox is among kids, right? And like video game, virtual reality environments. Even though I will admit, right, the Mark Zuckerberg version of the metaverse is pretty lame if you've been following it, but it's not really an unreasonable decision to think that the metaverse might become popular in the future, right? And so, yeah, it turned out to be a bad business decision, cost Facebook all these tens of billions of dollars. Really, the metaverse is, not really a big deal, at least not yet. And the share price of Facebook tanked dramatically last year. One footnote to this story, by the way, is that there was no fanfare or big announcement, but very quietly at the end of last year, Zuckerberg basically pulled the plug on the metaverse. He decided to lay off all the thousands of employees working on the metaverse and decided to stop pouring a lot of money into it. And so there wasn't a big announcement, but now the Facebook stock has now starting to go back up to its, pre-metaverse levels. But in Delaware, the board of directors, the CEO, the managers, or the members of an LLC, they have a lot of discretion in making a decision. You know what I mean? Because even if the decision turns out to be a bad one, the business judgment rule offers them some degree of protection. You can think of this as a legal insurance policy. By the way, before we now change gears, I want to mention one more thing about corporate governance that I forgot to mention. Remember, I told you the big picture. Sole proprietors and partners do not enjoy limited legal liability, but the members of an LLC or the shareholders of a corporation and do enjoy limited legal liability. There is a big caveat. There are 3 exceptions where the courts will. And in Delaware, it's called piercing the corporate veil. Under Delaware law, there are 3 limited circumstances where the shareholders of a corporation or the members of an LLC will be personally on the hook. And I want to share with you those exceptions because it's kind of important. One exception is going to be if the reason that when you, let me back up. One exception is going to be when you registered the company and you didn't comply with the registration requirements or the registration formalities. For example, you create an LLC, you file the articles of organization, but you don't pay the fee. Or you file a defective articles of organization with some of the information missing. You don't list all of the members of the LLC, for example, as is required. That's considered a defective registration, and it's as if the company didn't exist. The other second exception where you could be personally liable, even if you're an LLC or a corporation, is when the reason for the registration, let's say the registration is perfect, the fee is paid, all the paperwork has been filed properly, etc. But if the purpose of registering your company is to defraud your creditors, and this happens a lot, you'll set up maybe, Tiger King was a great example of this. When Joe Exotic was facing like $1 million legal judgment against him when he lost the case to Carol Baskin, actually it was a settlement, but he agreed to the $1 million judgment. Then what does Joe Exotic do? He actually creates a new LLC and transfers the assets to that LLC. And there he lists his mom and this guy, this scumbag called Jeff Lowe. If you saw Tiger King, you know what I'm talking about, as the owners of that other LLC. That was considered a fraudulent, registration. You know what I mean? Because you're doing that in order not to pay a court judgment that had been ratified by the court. And so that's not going to fly. You're going to be personally on the hook there. And then the third and most important exception, the one that I really want to emphasize, that's why I wanted to go back and share this with you, is what's called commingling. This is actually very important because, some shareholders are single shareholders. I'm sorry, some corporations are single shareholder corporations, and some LLCs are single member LLCs. But a common mistake is that the owner of the LLC or the shareholder of the corporation, they don't set up a separate bank account for the corporate entity. And if you don't do that, if you commingle the funds, that's considered, a no-no, and the court will be authorized to go ahead and ignore the corporate, the corporate entity and impose personal legal liability on the shareholder or the LLC member. So it's really important to have separate bank accounts, because, and so that, any money generated by the, whatever activities the LLC or corporation is doing needs to go to that bank account. Any, people the company does business with needs to be paid out of that bank account, not your personal bank account. So that's really, really important. I wanted to mention that because that's an important exception too. There's a fourth exception. That's not really an exception. It's when you sign a personal guarantee, right? When a shareholder or a LLC member, right, signs a personal guarantee, then of course you're on the hook. I don't really look at that as an exception. That's just, you just contract personal legal liability, you know what I mean? And sometimes what banks will do that. You're an LLC, but you're a small LLC with no proven track record. The bank is going to want a personal guarantee from each and every one of the members, you know what I mean? Before it might extend a loan, that kind of thing. So with that, let's continue our discussion of corporate governance. I talked about why Delaware is so popular among what I call the big boys or the big companies, but now I want to share with you one more aspect of corporate governance that's really novel. Completely new. I have throughout the semester, beginning with Face Mash, I've been ripping on Mark Zuckerberg really all semester long. It's hard not to, right? But I want to give Mark Zuckerberg some credit where credit is due. And that is a couple of years ago, he created an independent oversight board. And he promised to basically abide, by the decisions of the oversight board. No other company has done this. This is a very new method of corporate governance. Setting up an independent oversight board. And then basically allowing the independent oversight board to review decisions made by the company and then agreeing ahead of time to abide by those decisions. Now, a couple of things. I just want to throw it out there that I give Mark Zuckerberg a lot of credit because when he was creating this oversight board, part of it was public relations. He was getting a lot of bad press for all of the data privacy scandals, you know what I mean? And so he decided, well, I need to kind of deflect, and so let me create something, but he did follow through, and his company basically, on his direction, invested, I believe it was something on the order of several hundred millions of dollars to create an independent trust. So it's a separate legal entity, not owned by Facebook. They appoint their own directors, their own oversight board members, I should say. And they have an agreement with Facebook that they can review any decision Facebook makes to deplatform any of its users or to take down any content posted by any of its users. So I'll give you the most famous example of this, right? Donald J. Trump. You all know about the January 6th disturbance or the January 6th insurrection. By the way, interesting footnote, the US Department of Justice has prosecuted hundreds of people who were participating in the January 6th revolt. And many of those people are, live in Central Florida, are from Central Florida. Who knows if your neighbor, is a January 6th, rebel, but anyways, so Donald, the next day, both Twitter and then Facebook deplatformed Trump. I mean, they basically kicked Donald Trump off of Twitter and off of Facebook. And that was really big news because Trump was still the sitting president of the United States at the time. And, if you follow politics, you know that Donald Trump was the master of Twitter. He had a huge Twitter following, and also had a very decent Facebook following as well. So, that decision was, to deplatform Trump was automatically appealed to the oversight board. And the oversight board in May, so just a few months after this whole thing happened, they decided to say, you know what? Facebook did not violate its content moderation policies when they deplatformed Trump, but due process requires that if you deplatform somebody, one thing to take their post down, but if you entirely deplatform, shut somebody down completely, kick them off completely, you have to have a reasonable time limit on that penalty. And so Zuckerberg, true to his word, accepted the oversight board's decision and then limited the Trump decision, the time period in which he would be deplatformed to 2 years. And that 2-year period will expire now in December of 2023. By the way, it's my understanding that Facebook actually further reduced that sentence, and that Trump, is now allowed back on. But that's a pretty remarkable thing. Now, the reason why I say this is an experiment and we don't know really if it's going to succeed or if any other company will copy this Facebook model is because the trust is set to expire in 5 years, and Facebook, or in 3 more years, basically, and Facebook is not compelled to, renew the funding for the independent trust. And also the jurisdiction of the oversight board is fairly narrow, although they can review any decision that Facebook makes, content moderation, and I say Facebook, right? I should really be saying Meta, because that includes Instagram as well as Facebook. The oversight board can review any deplatforming decision or takedown, of a post decision. But what they cannot do is review Facebook's content moderation policy itself or Facebook's secret algorithms themselves, right? The jurisdiction of the oversight board is limited to takedown decisions. Now, to me, I say I still give Zuckerberg a lot of credit. To me, the glass is half full. Hey, that's better than nothing. But a lot of critics of the oversight board say that, it needs to go further to include, the actual, jurisdiction over the content moderation policy itself and over the algorithms themselves. So that's, a point of contention. Will the oversight board be renewed, when it expires, in a few years? And if it is renewed, will the jurisdiction of the board be expanded to include other aspects of, Meta Platforms policies? The other thing too is, as a practical matter, Facebook makes, not hundreds or thousands or tens of thousands, hundreds of thousands, even millions of takedown content moderation policy decisions, on a daily basis. And of course, the oversight board, although it has these very illustrious people, here are some of the 5 first members, including a professor of First Amendment law from Stanford Law School, including a professor, a friend of mine, Jamal Green, a fellow Yale, and now he's a professor at Columbia Law School. A lot of top people, including the former Prime Minister of Denmark, Nobel Prize, Peace Prize winners, etc. But it's only 34 of them. So even if you appeal, let's say you put a post on Facebook and you want to, it gets taken down and you want to challenge that, there's no guarantee that the oversight board is going to hear your case, right? They're probably all going to hear cases that involve, public figures like Donald J. Trump, or, issues that are in the news, what I mean? That kind of thing, conspiracy theories or whatever, So as a practical matter, I say it remains to be seen, if other companies and if Facebook itself will, continue with this model in the future. But it is, nobody else has tried this, creating, that's a whole new method of corporate governance. And I would keep your eye on that, because maybe other companies will decide to try this approach as well. All right. So now we've talked about corporate governance. I gave you the big picture. Now the main forms of doing business, right? Now, more importantly, why it is that Delaware is so special. Facebook or Meta Platforms being no exception. They're registered in Delaware. Although originally they were registered in Florida, when they became a corporation, they chose Delaware, right? And part of it is because the Delaware courts are really excellent courts, and super highly respected. and super efficient, and the business judgment rule, the actual body of common law that the Delaware courts have developed in interpreting the fiduciary duties of CEOs and board of directors. They interpret it in a giving the business person the benefit of the doubt. All right. And now we see this novel form. I just want to throw it out there because I wanted to give Zuckerberg credit for trying something new. Now, in the second part of today's class, I want to share with you, let's talk about business ethics, right? This is the legal and ethical environment of business. Now, my understanding is, I think there are other courses in the College of Business that focus exclusively on ethics, maybe in the management school. But our class is called Legal and Ethical Environment of Business. And whenever we talk about the law, right, there's always these interesting questions of what is the relationship between law and morality, or law and ethics. So what I want to do here is end the course by, I'll end the course by sharing with the class the survey results, but substantively, let's end the course by talking about corporate social responsibility, which is sort of like the terminology that is now used for business ethics. Often this is also called, you may have heard of ESG. There's this company called Yahoo Finance that gives these ESG rankings, to the big publicly traded companies. And ESG stands for environment, social justice, and governance. So the idea is, what if any ethical obligations does a company owe to the society, or to the broader public at large? Now, there's actually three theories. Let me just say that. The first theory is that this is a nonsensical, stupid question, because we're talking about business entities like corporations and LLCs. At law, these are considered artificial persons. And so it seems almost silly to talk about an artificial entity, acting morally, right? It's one thing to talk about a human being. When we talk about ethics and morality, natural law, for example, natural rights, we're assuming human beings. Maybe we want to expand that to the animal kingdom. One of the great things about Tiger King, it makes you think about what are our duties, ethical duties towards animals. But what about, companies? A lot of times, this whole thing is sidestepped by using the language of business ethics or using the language of corporate social responsibility. We just assume that companies do have an ethical obligation. But, as a scholar, that's sort of assuming into evidence, conclusion, but that said, that would be a complete, minority view. There are two major theories of business ethics. If you do assume, if you do accept the premise or the assumption that business entities do have an ethical obligation, then you have to ask yourself, okay, what are those ethical obligations? And there are two answers to that question. One is called the Friedman Doctrine, and this has a lot of different labels. Often it's called the maximizing profits model or the moral minimum model, and I'll explain why those terms are interchangeable. And then that's a much more, I'll just say it right now, it's a much more narrow theory of business ethics. And then you have something called good corporate citizenship, or the stakeholder interest model, the stakeholder model for short, which is a more, if you will, robust, a more expansive theory of business ethics. So let's talk about both of these theories. Let me begin with Milton Friedman's theory, or the maximizing profits. It is often called the Friedman Doctrine. And there's a very nice, I put in the module, the Wikipedia page for the Friedman Doctrine, if you want to further explore this. What the Friedman Doctrine is named after Milton Friedman. And you may not know who that guy is. He was an economist at the University of Chicago in the 1950s, 60s, and 70s and 80s. He had a special program on PBS called Free to Choose with his wife, Rose Friedman. Very influential, trying to put the ideas of Adam Smith. And he also wrote a book, popularized, I should say, the ideas of Adam Smith. And he also wrote a book, bestseller book, called Capitalism and Freedom. It is an excellent book. Because of my new setup with the Ethernet cable, I can't just reach, otherwise I'd reach in my bookcase and get it for you. Sold millions of copies. It's been translated into dozens of languages. And in Capitalism and Freedom, which he co-wrote with Rose Friedman, his wife, he says, the corporate, the ethical obligation of a company is to maximize profits. Now, in Capitalism and Freedom, Milton Friedman makes an important caveat, and it's why this theory is often called also the moral minimum. He says, but the company has to, always obey the law. As long as you obey the law, you have, and you, the company, you have discharged, you have complied with your ethical obligations to society. That's what this theory is. So go ahead and make a lot of money. That's what you're in business for. This theory is a very popular theory for a couple of reasons. One reason is it fits nicely with the common law duty, fiduciary duty I was talking about, that if you're a corporate manager, if you're a partner, if you're a member of an LLC, you always have to act in the best interest of the company, right? And so the idea is that means, the fancy term is you have to maximize shareholder value. If you're a board of directors, CEO, you're making decisions, right? You want to make a decision in the best interest of the company. And that's equated with, okay, maximizing shareholder value. How do you maximize that? Well, by focusing on profits, focusing on the financial health of the company. Now we could go into the weeds and, with accounting majors I have there, how do you define profits, that kind of thing. But I just want to give you the basic idea. You know what I mean? The other reason why this is popular, or influential theory is it's built in effing Friedman. This guy is like writing best-selling books, very influential economist. At the time, he was a rock star. He was on the cover of Time magazine multiple times, advisor to presidents, very well respected. You know what I mean? But it goes beyond that. The Friedman Doctrine is its intellectual pedigree goes all the way back to 1776. And two big things happened in 1776. We already talked about one of them in the first lab of this course. We talked about the Declaration of Independence and the theory of natural law and natural rights as a source of law, right? But the other big thing that happened in March 9th, 1776, is that Adam Smith published The Wealth of Nations. And The Wealth of Nations contains a very famous sentence that says, we do not owe our dinner from the benevolence of the butcher or the brewer or the baker, but rather from a regard to their own self-interest. This is often called the invisible hand theory. Later in the book, he says, I'll put this in plain English. If everybody is just pursuing their interest, right, maximizing their profits. Again, Adam Smith clarifies, remember, he's a moral philosopher before he became an economist. You still have to obey the law. But as long as you're obeying the law, if everybody is maximizing their profits, the idea is, Adam Smith says, it would be there's an invisible hand that will create the greatest level of prosperity for everybody overall. You know what I mean? Doesn't mean that there won't be some poor people, some homeless people, but it does mean that overall you'll have a much more prosperous and wealthy society if you have, everybody pursuing their self-interest. So it's the invisible hand theory, super powerful, right? And so that is why, even though I will say the maximizing profits, Friedman Doctrine, moral minimum, whatever you want to call it, even though it's highly ridiculed by by a lot of, liberal law professors and a lot of people with fancy degrees, it has a really powerful intellectual pedigree, and it has the virtue of being pretty simple. You know what I mean? Don't break the law, and then focus on the bottom line. Now, of course, I'm a professor, so I have to be fair and balanced here. And what are there any weaknesses with the theory? And there are two weaknesses. I want to be fair and balanced. There are two weaknesses with the Friedman Doctrine. One weakness is focus on this moral minimum aspect that, the only ethical obligation a company has is really to not break the law. You know what I mean? The one critique is that what Friedman is doing, and even Adam Smith, if you want to go back to him, is they're equating ethics with law. And the problem with that is, of course, what happens if you live in a country or a state that may have an immoral law, you know what I mean? Or an unconstitutional law, like the TikTok ban that UCF, personally, my position is that that's totally unconstitutional. You know what I mean? You just can't invoke national security and, without a vote, expect people to accept that. You know what I mean? What happened to due process? What happened to property rights? What happened to freedom of choice? You know what I mean? What happened to the free market, et cetera, right? So, but this is one criticism that, just complying with the law is enough to comply, to be an ethical company. Well, what happens if the law itself, might raise some ethical questions, The other criticism, though, and I can basically refute, and I'm a big Milton Friedman guy. I'll put my cards on the table. I saw Free to Choose when I was a kid, changed my life forever. Huge Adam Smith fan. My 50% of my scholarship is all about Adam Smith because he was actually a legal scholar before he became an economist. But look at this guy, right? Did you know who this guy is, right? Pharma bro, Martin Shkreli, right? He did everything that Milton Friedman said you should do. Maximize profits. What did he do, right? He bought, before he was put into prison for fraud, he legitimately bought the patent rights, to a pharmaceutical drug, right? And then he jacked up the price of this life-saving drug 5,000%, you know what I mean? And a lot of the people, couldn't afford that price, or it was, considered price gouging. Or think about after Hurricane, Irma or whatever, last year, last semester, you know what I mean? You go want to get a bag of ice and it's $20, isn't the company just maximizing? So there must be, this is a very powerful counter refutation. You know what I mean? Very powerful counter refutation that there's got to be some limit. You know what I mean? And maybe the maximizing profit moral minimum model, although it has a powerful intellectual pedigree, right? Maybe it doesn't tell the full story. So what is the full story? Well, now we have this other theory. This other big theory of corporate social responsibility or business ethics. And it's called the stakeholder model. And what the stakeholder model is, I have a simple diagram here. So I want to make it really understandable. By the way, I know a lot of you study this in some of your management courses, and there are much more better graphics, like, the external stakeholders and the internal stakeholders, and there's like 20 of these things. But let me just keep it simple so that we can appreciate the beauty and the power of this model, and why it's so popular and why it's considered a response to the Friedman, some of the weaknesses of the Friedman Doctrine. So a company, whenever a board of directors or CEO, whenever a company is making decisions, right, it's going to affect different people. And those different people might belong to different groups, different constituencies. We call them stakeholders. Now, this is important. You don't want, you want to get this right. I'm not talking about shareholders. Shareholders are just one stakeholder group, the owners of the corporation. I'm talking about everybody else, the employees of the company, right? The workforce. I'm talking about the creditor institutions, people who have, instead of equity, a debt obligations that extended to the company. The suppliers, the other companies that the business does business with, you know what I mean? The environment and the local community in which the business is located and in which the employees are located. And perhaps most importantly of all, right? Your user base, if you're a tech company, or your customers, if you're a traditional company, right? Let me give you an example. To me, the most dramatic example of the stakeholder model, Donald J. Trump, do you remember the 2016 presidential election, right? About 5 years ago or almost 6 years ago? And Trump is calling out big companies like Ford, the Carrier Corporation, why? Because a Carrier, for example, and Ford, they had factories in Indiana and in Kentucky, and they're going to shut them down and relocate to overseas, like, the maquiladoras in northern Mexico, for example, And so Donald Trump is saying that's totally, what about your employees, It's not just about making money. It's about, it's also about taking care of the people who work for you. And I mentioned this example because, I'm no political scientist or anything, but, a lot of these so-called Rust Belt states, like Ohio, Indiana, Wisconsin, Michigan, Trump won. You know what I mean? A lot of workers, blue collar guys and women voted for him. You know what I mean? So it's like really resonated with the public. And so it's a very powerful example of the stakeholder model in action. Now, again, I'm a professor, so I always have to find, I got to be that guy, got to find a problem with the theory. And unfortunately, the theory is also, it's a good theory, very popular theory. But there's a powerful critique. There's actually two powerful critiques. One critique would just go back to Adam Smith. What do you mean you have to take into account your customers? That's what markets are for, right? As long as there's competition, reasonable government laws and regulations and the common law and whatnot, right? The market will make sure that the companies have an incentive to take care of the customers. This is a completely redundant theory. You know what I mean? The other weakness is, notice I didn't put the shareholders here. I just identified the other major stakeholders. But the other critique is, and let me just show you the slide, is this. Look, and this is something that to me really bugs the heck out of me. Every time I hear people talking about the stakeholder model, I always ask them, okay, well, what weights do you assign to those groups I just showed you? You know what I mean? What weights do you assign to those groups? Are they equally weighted? Are they equally important? Or maybe are the employees like Trump, are they the most important group? You know what I mean? Or is it, or is it all equally weighted? So the problem is, right, if you don't, and let's go back to Carrier, right? Let's go back to the decision to relocate to Mexico, that definitely hurts your employees, right? I mean, it benefits the Mexican workforce, right? But it hurts your North American, Indiana employees, right? But now think of your customers, right? Assuming that the air conditioning, which are, now what these are. They have central, it's called HVAC, right? They do heating, they do air conditioning, super efficient. They're super expensive as well, right? So I'm assuming if you relocate your factory to Mexico and you build your F-150 truck or your HVAC unit, it's going to be cheaper for the public. Maybe I can save $5,000 on an F-150 truck built in Mexico. You know what I mean? So, again, here, in other words, what I'm saying is, what happens if you have a conflict of interest among your competing stakeholder groups? See, stakeholder theory makes sense if all of these interests, of all of these stakeholder interests are aligned. But what happens in the real world where there's a conflict of interest among the stakeholders? So if you're an employee, you want to keep your job. But if you're a customer, you'd like to save a few $1,000s on your next truck or HVAC unit, right? So when there's a conflict, I need to know what the weights are in each of these categories or stakeholder groups so I can make, a rational decision here, not just make stuff up. So the ultimate critique, and by the way, I owe this to my friend and colleague, Professor Bainbridge at UCLA, the ultimate critique here, stakeholder theory is completely wishy-washy because nobody really assigns specific weights. The company's they're going to say the company will say that they consult their stakeholder groups, but they really don't. They just what they're really doing is focusing on the bottom line. That's why I have this picture here. Like, think about Mr. Zuckerberg himself. What do you think, what model do you think really best explains his business decisions? I'm not saying what you would like him to actually do, but what does he actually do? And so Bainbridge says, I'm going to say I agree with him here, that in reality, these companies, they talk a good game, they talk about the stakeholder model, but in reality, when they're making decisions, it's all bottom line. You know what I mean? They're basically doing what Milton Friedman says they should be doing. All right. One more critique I should say of the stakeholder theory is that, and I'll tell you, the stakeholder theory, and this is my critique that I would go above and beyond Bainbridge. To me, it's a redundant theory, not just because, you don't need to have customers in there. That's what markets do. Customers are going to buy the best products at the best prices if there's a free market. But if shareholders get the biggest weight, then this theory is redundant. You know what I mean? It's like that you're just doing the Friedman Doctrine. Oh, this is window dressing. So tell me what the weights are. Are they equally weighted? It's one thing if you're telling me shareholders have an equal weight as employees, and employees have an equal weight of these other groups. But even if they all have equal weights, then what happens if there's a conflict among the stakeholder groups? And if they don't have equal weights, if the shareholders ultimately have the greatest weight, then this theory is doing no work at all. So, I like to say, both of these theories, these are two powerful theories of business ethics, and they both have problems, right? The Friedman Doctrine might be a better description of reality, but then you have this problem, right? You could just take it too far. And this, at one point, this guy was the most despised man in all of America, and the problem with the stakeholder model is that, you need to assign weights to these groups, and, I've seen, I do a lot of reading, I haven't seen a single peer-reviewed paper, even a blog post in which anybody attempts to do that. So I want to end on one last point. Actually, I said I would end on business ethics. I do want to talk about the Accountable Capitalism Act. I've been talking about Donald Trump, so I'm talking about the other side now. Senator, my friend and colleague, Senator Elizabeth Warren. She was a law professor before she became a senator, U.S. senator. And then my fellow kindred spirit, Alexandria Ocasio-Cortez, you know what I mean? Who's in the House. And they both have, presented to the respective houses of Congress companion bills called the Accountable Capitalism Act. This bill, now it's just a proposed piece of legislation. It has not been enacted into law. But I am based on let's say, how Donald Trump won the election in 2016. I think this is a big issue. And I think the Accountable Capitalism Act will get a lot of publicity and may even get a hearing, maybe even a Senate floor vote, House vote if the Democrats get back in charge, in the near future. And what this bill would do, if it were enacted into law in its current state, it would do three things. First of all, let me just back up and say the bill would only apply to companies that make, over basically $1 billion in revenue per year or more. I looked it up. It's about 3,100 companies in the US that this bill would specifically apply to. So let me just make that very clear. It would only apply to a small subset of the publicly traded companies, big big publicly traded companies that are making, billions of dollars in revenue a year. Now, one thing it does, number one, it creates a new government department under the Bureau, under the Commerce Department, the new U.S. Office of Corporations. The reason why is because if you're one of these, 3,000 companies making billions of dollars a year, you not only have to register in one of the states, most likely Delaware, you're now going to have to register in this new federal office. So there's that component. Why? Because the bill does two additional substantive things. One is it substitutes the common law fiduciary duty that we were talking about at the beginning when we were looking at Delaware's business judgment rule. It would substitute that with the stakeholder model. So it would basically make the stakeholder model, it would legislate the stakeholder model for the biggest 3,000 companies in the US. It would say, look, this is now what you're going to have to do. And that's why, by the way, you need this new U.S. Office of Corporations, because what the bill does is it says if you're in non-compliance, if you are not actually taking into account the interest of your stakeholders, all your stakeholder groups, you could lose your federal charter. And if you lose your federal charter, it's like we're shutting you down. We're putting you out of business. You know what I'm saying? So that's perhaps the most controversial aspect of the bill. I would just say in defense of the bill, that, you have to have teeth, right? It has to have a penalty. Otherwise, the bill is just, wishy-washy like the stakeholder model. So this raises one last question that the bill will answer, and that is this. Okay, if you're going to legislate the stakeholder model for these big companies, if you're going to replace the fiduciary duty where the company has to act in the best interest of its shareholders or of the company itself with a more broad stakeholder model of ethics, how do you prove that? And one of the things the bill does, it would require, by the way, the bill does many other things. I have a Wikipedia link in there, but these are the big three things that affect us the most. It would require that the board of directors of all these 3,000 companies I'm telling you about, the employees would be allowed to elect, I should say, 40% or more of the board of directors. So right now, the way the board of directors works is they're elected by the shareholders. Right now, the way it works in practice is that the CEO will basically have a list of the people he or she wants on the board of directors. And then at the annual shareholder meeting, then the shareholders either vote yes or no to that. So it's more of a rubber stamp. Now, the shareholders and the employees would have a right to vote. My best analogy here would be like the board of trustees of the University of Central Florida and most major universities, public or private. Usually the board of trustees has a student representative. Usually it's like the president of the student government, whoever the student leader is, and the idea is, stakeholder model, right? You want to give students, at least a voice, If you're really about your stakeholders, then you have to listen to what your stakeholders are saying. Now, notice Elizabeth Warren, as you could say she's far left and AOC, but it's really interesting. They're not requiring that 50% or more be elected by the employees. They're saying at least 40%. And so, but what I like about the bill is two things. They are assigning a weight to at least one of the stakeholder groups, and they're calling out the hypocrisy, not to say BS, of all these, woke corporations that say they're about the stakeholder models. But in fact, if you look at the board of directors, of the Fortune 500 companies, actually of all 3,000 of these big companies, what you're going to find is that their board of directors, and I'm telling you this because I've done the research, I've looked at this, not a single one of these companies have a single employee on the board of directors, right? But why? Because the board of directors are elected by the shareholders, and it's the CEO who, basically decides who's going to be, eligible for being on the board of directors. I've included, you don't take my word for it, I've included in the link, one of the links in the module, Facebook's management team and their board of directors. So you can see now Facebook, I give them a lot of credit. Unlike most of these big tech companies, Facebook's board of directors, it's very ethnically and diverse. It's has a lot of women on the board of directors. It has Mark Andreessen, who is a legend in computer science. He created the Netscape browser. Peter Thiel used to be on the board. The founder of Dropbox is on the board. Executive from Estee Lauder is on the board, a partner at McKinsey consultant. But as diverse as that board is, there's not a single employee on the Facebook board of directors. And so, you can see where this bill would say, hey, you got to stop that. You got to stop saying that you're woke and you're about the stakeholders, when in fact your board of directors is made up of all these, powerful and wealthy people, these elite, you know what I mean? So even if you don't like the bill, I find that one of the delicious ironies of the bill that I kind of hope it moves forward. Regardless of whether you're for the bill or against the bill, I want to throw it out there because it's called the Accountable Capitalism Act. And even if it doesn't get enacted, right? Unlikely now that the Republicans control the House. But that said, right, Donald Trump was a Republican and he was a whole big thing about the employees. But that said, this has potential bipartisan support, at least some aspects of the bill, right? The employee aspect, perhaps. And furthermore, even if the bill's not enacted, let me say this, I think it will be part of the national conversation in the 2024 and 2028 national elections. I think more people are going to realize, one of the things I ask you on your final project is tell me the salary of the CEO. And a lot of people say that's perfectly fine. CEO, if the company is making money, the CEO should be making money. But a lot of people find it obscene, that, the CEOs are making millions of dollars per year. And that's not including stock options and all where they get their real money. Whereas the employees are making the same salary as they were making as back in 1980, once you adjust for inflation. In fact, they're making less money in some respects because they're working harder with emails and all the stuff you got to do now 24/7. So I really do think this will be a part of the national conversation, and business ethics will become, people will be talking about it. People will be talking about variations of the Friedman model, variations of the stakeholder model, and whether we should legislate, business ethics into law. I'm not saying one way or the other. I think it's up for each person as a good citizen, as a good, thoughtful college student, with a liberal arts degree. You make up your own mind, what you think the best theories are. What do you think of the Accountable Capitalism Act, et cetera, et cetera. All right, that basically does conclude the lecture part of the class. But let me just end by, let's look at the survey results. Let's think what students think about this kind of stuff. So what I'm going to do is I'm going to end the screen share and show you the survey results really quickly, because we have concluded the lecture. I need to end the screen share just so I can get out of the PowerPoint. And let me just pull up the survey. Let me start with the extra credit survey. And give me 1 second here. All right, let me go to survey statistics and then I'll do a screen share. All right, this just happened in real time. We were supposed to meet in person last week. It was, Passover, Holy Week, Ramadan, a lot of things going on, Hall of Fame. So I said, let's just do our regular Zoom this week. And then if you want to meet in person, we'll do that the last week. But during that hiatus, all of a sudden you can't use TikTok and WeChat and a bunch of other things. So let's go ahead and look at the survey here and see what the class thinks about all of this. All right. Now, this is just 2 questions because I just made this on the fly. By the way, I made a mistake. I meant to replace the, you notice the actual survey, which I'll show at the very end, has some questions about monopoly law. I wanted to replace those with my TikTok. I forgot to hit save, so I lost those questions. So I decided, let me just make an extra credit. That way, if you did miss, a survey or anything like that, you can get these points, like some partial points. So you can see my first survey question here. Hopefully, you're seeing this, right? You're seeing the survey question here. This should be not news. We all got emails. This was in the news, local news as well. So TikTok's been banned, right? TikTok has been banned. So at least on campus, and this is true. Like I had the TikTok app on my office computer. I noticed when I made it back to campus earlier this week, I noticed that was gone. Gone. And then when I tried to, out of habit, look at some of my favorite TikTok accounts, that was gone as well. I couldn't, I got a nasty message saying I couldn't access that. Let's see what the class thinks here. Do you agree with the decision? Now, notice, right? It's a pretty overwhelming majority does not agree, but a substantial fraction of students do agree. You know what I mean? So this is something that, on the merits, and it's really two separate questions. Does the board of trustees, or board, in this case, the board of governors, which sets the policy for all the public universities in our state, do they have the legal authority? And assuming if they do have the legal authority, is this a good policy? So you could say maybe it is a good policy because of the whole data issues, you know what I'm saying? But of course, the hypocrisy that, Facebook's data policies are, you could say are worse, and their track record is awful, but, and you could, and then you could try to say, oh, well, Facebook, unlike TikTok, is not owned by, it doesn't have a relationship with the U.S. government. Of course, I'm going to just say, what world are you living in? Because the FBI does have a backdoor to everything that's on Facebook. So I'm kind of wondering myself if, and I could be wrong about this, but I think this is just ugly hysteria. There's a moral panic. You know what I mean? Personally, but I could be wrong. I could be wrong. Maybe there's a genuine national security issue here. But if there is, I trust Facebook as much as I trust TikTok, let's put it that way. The next question is, regardless however you feel, why were we never consulted here? You know what I mean? What happened to the stakeholder model? You know what I mean? If anybody's going to do the stakeholder model, you would think it would be a publicly funded university, right? That doesn't have to make a profit, right? And let's see what the class thinks about this. And notice here, overwhelming, 80%, yeah. I mean, where is the democracy here, right? So I do want to throw that out. That's kind of one of the ironies of this whole situation. Let's look at our other survey. Let's look at our other survey. And what I'm going to do here is just refresh it, make sure I get all the most recent results. And let me do this. Let me just get out of the screen share just to make sure we're in the proper we're in the proper survey. This was our last survey of this semester. Now I'll do the screen share. Make sure there's no problem here. All right, so let's go down to survey statistics. Now I'll go quickly over the first three questions. I meant to take those out because, okay. But let's see what the class thinks about whether Facebook is a monopoly, or Meta platforms, whether they're a monopoly or not. This raises a whole other issue of antitrust law. And the purpose of these questions is just to show you, this is a real time. This is actually a lawsuit is right now pending that the Federal Trade Commission has brought, not just against Facebook, Meta platforms, but also against Alphabet and Google. So let's see what the class thinks. Do you agree with the FTC that Facebook has, is an illegal monopoly? And what you'll see here is surprising numbers. I will tell you what's really interesting about this is when I started conducting this survey. Again, when this was lecture capture, we had regular classes. I would lecture on each and every aspect of antitrust law, normally these numbers were flipped. Like when I started doing this a few years ago, the numbers were flipped. Every time I do the survey, more and more students are saying that this like last time it was like 60%. Before that it was 50. It just keeps going up and up and up, which tells me that if this case goes to a jury, there's probably Facebook should be really worried. The next question is well, what's the remedy here? You know what I mean? Okay, it's a monopoly. So what? What do you do? Should we break up the company? And what's really interesting here is notice there's a small discrepancy, about 6%. You know what I mean? It's one thing to say that you've done something wrong, illegal monopoly or attempted monopoly, but then what's the remedy? And under the antitrust laws, one of the remedies, and the remedy the government is seeking here, is to break up the company into smaller units. And so this is very controversial, by the way, among economists and antitrust lawyers, because, if you're really serious about Adam Smith and all that, you would say, well, this is good. You should have more competition, break up all these companies into smaller companies. But a lot of antitrust lawyers and economists would say, that's what they debate. How many firms do you really have to have for a market to be competitive. And so that's a real debate. You know what I mean? Is 2 companies enough? As long as you have Pepsi and Coke, do you need all these other small companies? You know, and so there's a legitimate debate in the economics and scholarly literature about that. The next question here is just about the oversight board. What do you just do? I wanted to get again. I meant to replace this question with the TikTok question. There was a third TikTok question that got lost, but notice here, right? There's a the reason why I asked this question though is if you look at the oversight board, right? You could say that Zuckerberg is a strategic genius because some people are saying, look, that 2-year suspension is way too short. You know, others are saying it's way too long. You know, and then another third is saying it's about right. So note if you're Mark Zuckerberg, right? You're a business person, right? You want to keep, you want to have both Republicans and Democrats, pro-Trump and anti-Trump on your platforms, right? Last thing you want to do is alienate a big group of people, the way Elon Musk seems to be doing with Twitter. So, once you allow the oversight board to make the decision or to compel you to make a decision, now you can at least shift the blame to the oversight board. So you could say this is Zuckerberg just a strategic genius here, but it's a healthy debate about that. What about this? Okay, now let's do these. What does my class think about the oversight board? Should other companies try it? Should maybe even legislate? And notice here. Again, the response seems to be less and less trust of big corporations, and so maybe other big companies should have an oversight board as a way of building that trust. I find it fascinating that I think that's why I give Zuckerberg credit for trying to do this. You know what I mean? All right. And then I think this is the next to last question. What does the class think about the Accountable Capitalism Act? And I got a summary there. I got the 2 main co-sponsors. By the way, interesting factoid: Vermont Senator Bernie Sanders, who's probably the most most left wing. He is not a co-sponsor on this bill for whatever reason. I don't know. Doesn't like his Senator Warren to steal his thunder or whatever. But it does have some other supporters. And what's surprising here, at least to me, is that big percentage of the class actually supports this innovation. My very last survey question is, by the way, this bill, if it does go any further, I notice, right, even though the Democrats still control the Senate and Senator Warren, I think she's chairman of the Finance Committee, they still haven't held a hearing on this bill. At least the last time I checked. So I kind of find that ironic. That is this, are they serious about this, or are they just bluffing, to scare companies into actually, doing the right thing? A lot of times companies, to avoid regulation, they will what's called do self-regulation. Okay, we're going to adopt this ourselves. You know what I'm saying? We're going to actually have some employees on our board. Maybe not 40%, but at least 1 employee, that kind of thing, So we'll see. That remains to be seen. The last question is, one of the interesting things from a cinematic perspective about the social network is that, normally a movie, there's, a novel, a story has a villain, Here it's not clear who the villain is. Everybody here, nobody is perfect. Notice what's interesting here, right, is that Zuckerberg kind of outshines everybody else. He stabbed his partner in the back and sued him. Stole the idea from the Winklevi. He fired Sean Parker as soon as Sean Parker got into some legal trouble. Let me end the class by showing you who owns Facebook today, and show you one of the ironies. Of the world, and this maybe will give you some food for thought. That I hope you think about over the break. So let's go. Who owns Facebook? And I just want to show you. Now this is based on data. When Facebook went public in 2012. So some of these people may have cashed out. By the way, let me end the screen share very quick, because I want to go from the bottom up and just show you. Okay, the class has pretty much 61%. You can make a case that nobody's perfect, right? Everybody does some bad things in here. You know what I mean? Sean Parker's doing drugs and partying with underage girls. Eduardo Saverin is freezing the bank account. Peter Thiel, you could say, is orchestrating this whole thing from the back. Hold on here. This is not the one with the pictures. Let me get the right one with the pic. Oh, here it is. I skipped over it. All right. Let me make sure this is the right one, and then we'll end the class on this note. let me see where my scroll function is. I'm working with two screens here. Let me make sure these pictures are loading. And I apologize, I have this pulled up, but I accidentally closed it. Yeah, where did it go? All right, let me see if here it is. This should be it. Let me just. All right, yeah, this is perfect. Let me do the screen share and I'll kind of go in reverse order, but notice sometimes there's no relationship, sometimes karma is slow. There's no relationship between whether, you act ethically and you have success. And this is one of the things I like about the social network is it makes you think a lot. Like, Peter Thiel's not necessarily a bad guy. You may not like him. He came out in favor of Trump. He funded the Hulk Hogan lawsuit against Gawker, effectively shutting down that lawsuit when that company when Gawker lost. But he's one of the big owners. Of course, Sean Parker, right? Another big. By the way, let me just show you their percentages, right? How much they ended up with. But it does say Peter Thiel, but it's almost as much as Sean Parker. So he did pretty well for himself. This is a top 10 list. I'm going in reverse order here. Eduardo Saverin, he got a pretty decent settlement. Ultimately, what happened was, even though it wasn't publicly disclosed at the time, there was a confidentiality clause, right, non-disclosure agreement. What happened is when Facebook went public, right, part of the SEC disclosures is you have to list who your main shareholders are. And so when you're a privately held company, you don't have to do that. But when you're a publicly traded company, you do have to do that. And so what ended up happening is Eduardo Saverin and Mark Zuckerberg settled, look, I'll give you the same amount that I gave to Sean Parker and Peter Thiel, which, and, you could say that was a fair settlement, right? The other, Dustin Moskovitz, I have to shout him out because he was born in Gainesville and grew up his entire life in Marion County, Ocala, so he's, not only a fellow Floridian, he might even be, a neighbor of yours, if you're from those neck of the woods. And he was one of the original founders of Facebook. I will tell you in 2008, he amicably parted ways with Facebook. But he just because he went to set up his own company called Asana, which is like a Facebook for like, internal Facebook or social media for companies. But Dustin Moskovitz has what's called a proxy agreement, voting agreement with Mark Zuckerberg, that Mark Zuckerberg is allowed to not just vote his own shares, whenever there's a shareholder meeting, a Facebook share or Meta platform shareholder meeting, he's also allowed to vote the shares of Dustin Moskovitz. So that's why Zuckerberg still has a lot of clout in the company, because he has these proxy agreements with a lot of his original co-founders. Excel Partners, do you remember we talked about Excel Partners in the last class? Is the reason why Eduardo was diluted in the first place, because Excel Partners came in. They were the first major, after Peter Thiel, the first major outside investor, right? And they did very well for themselves as well. And of course, on the top of the list, right, is Mr. Zuckerberg, right? The person who the class said is, if you're going to pick one person who's the villain of the story, he's the guy that's the, on top. You know what I mean? Now, true, he took a bit, assuming these guys did not sell any of their shares prior to the whole metaverse disaster, they lost a lot of money in terms of their personal wealth, when the Facebook stock tanked. I will tell you, some of these individuals like Peter Thiel, like Excel Partners, did sell their shares, you know what I mean? So they, when it was still at a high price, maybe not as high when it was at its all-time high before the metaverse. But Mark Zuckerberg is still a substantial shareholder in the company. And so he took a big personal hit, when the metaverse disaster, occurred. Now that he has quietly shelved the metaverse, basically, at least for now, the Facebook stock is coming up. The point is this, you know what I mean? Whether he's a net worth is $50 billion or $100 billion, Mark Zuckerberg is a very wealthy individual. And it's kind of ironic, right? That the person that the class said probably had the least amount of business ethics is the person who's on the top of that list that I showed you, right? So I didn't want to throw that out there. Now, I do believe in karma. As Dr. King famously said, the arc of justice is long, you know what I mean? And so maybe eventually, it'll all come back to him, but I do find that ironic, in some respects. And I just throw it out there, and then, got to make what it's worth, because to me, as my own, I was a Spanish literature major in college, and as one of my own professors would say, life is stranger than fiction. All right, here, let's go again. Basically, class is now over. If anybody has any questions, comments, or concerns, okay, survey link. Let me put in the survey link in the chat. So I'll do both surveys. Let me first put the survey for the class activity, so you get the full points, since you're in here, and then we put the survey for the extra credit. So both of the surveys are there. The second one is for extra credit. That's the TikTok survey. And the first survey is the actual, the activity for this class, which was a survey, just to get the student feedback, what you think about these issues. So that's in there. I will stay on the line. My TA, let me see here, because I had to push back the class, you know what I mean? There may have been, she may not still be on. Yeah, we're almost at 8:30 here, but I will stay on the line. You can either, if anybody has a question, you can either message me privately and I'll go ahead and address it, or you can, if you don't mind, maybe other classmates have the same question, you can put it publicly in the chat or unmute as well. You know what I mean? Oh, great comment here about, is Facebook a platform or a publisher, right? Excellent question, because on the answer to that question resides whether Facebook will continue to enjoy what's called Section 230 immunity. This is something that I don't talk about in this class, only because this is a survey class, but I do talk about in my advanced topics class, because the Section 230 immunity issue affects all the big tech companies, not just meta platforms. And so this is a debate right now. Technically speaking, from an economic perspective, Facebook is a platform in that, let me give you the classic example of a non-controversial platform. From a definitional perspective, is Amazon, right? Amazon puts together buyers and sellers. Some of the sellers are third-party sellers, vendors that Amazon has approved. Some of the the main seller, those Amazon itself, right? eBay, right? One of the famous original internet companies from the 1990s, right? It brings together buyers and sellers. So economists say, and antitrust lawyers, whenever you put together, or Match.com, dating sites, whenever you put together people and match them up, either to buy or sell stuff or to share information like a social media, Instagram post, whatever, there's the people who post the pictures on Instagram or the TikTok videos, and the people who download those posts or watch those videos, right? You're a platform. Now, the publisher is very, very interesting, right? Because technically what the argument Facebook makes, this is a great question, by the way. Facebook says they're, YouTube, Google, they say they're not a publisher because what they're doing is they're allowing other people to publish their stuff. Now, the counter argument to that is, well, but Facebook and YouTube, right, Google, you have very strict content moderation policies. So when you decide to take certain posts down, even though there might be an oversight board to review that decision, you're still taking stuff down. And that looks like you're making a publishing decision, an editorial decision. And to me, that's actually a very good argument. Let me just say right now, I forgot to mention this because we had a lot to talk about, but there's actually a lawsuit pending right now against Facebook and Twitter, for that matter, alleging that very issue. And again, the plaintiff is none other than Donald J. Trump. He was kicked off of Twitter. The lawsuit with Facebook will become moot, probably will get dismissed by the courts just because Facebook has now let him back on, or is about to let him back on, But with Twitter, and now Elon Musk has allowed Donald J. Trump back on, President Trump back on. So again, courts might say that's moot. We'll see, but he was deplatformed for a substantial period of time. So, he might still be entitled to some damages, if they find that these companies are a publisher. But right now, no court, that's going to have to go up to the Supreme Court, No, all the courts have basically ruled for the big tech companies. Feedback on the final project. Oh yeah, wonderful. Yeah, so basically what I would do is, if you want feedback for the final project, I would submit it, because I'm going to grade the ones that are submitted. I'm going to grade early, and then I'm going to leave it up so you'll have a chance to revise them. You know what I'm saying? So What I'm going to do, just because I have so many students, I actually don't mind grading some of these projects early, so I have less things. My TAs and I will have fewer projects to grade. So as long as you get your project in by, I would say, Sunday or Monday, the deadline's not until April 24th. It's a whole 10 days away. You know what I mean? 11 days away. But if you do submit it by this Monday, at least a week in advance, I will grade it, on Monday night, Tuesday morning, and then I'll keep it there, with all my comments for 1 week, and then you can make revisions. That's what I'll do. That will be my reward if you submit your project early. Yeah, and you will be able to edit after the feedback. Basically, normally, by the way, my impression is students who submit early, usually do very well. You know what I'm saying? It's like they're, you're on top of your stuff. You know what I mean? You're on your A game. So yeah, you will be able to. That will be the whole advantage of submitting early. That you could, if you did want to make edits, to improve your score, you can do that. So that I will do that, and I'll update the course homepage to reflect that policy. Let me see here. Any other questions or comments? Yeah, go ahead. Oh, by the way, quick timeout. Let me go ahead and end the recording, just because I don't want this to be like a 2-hour thing. For purposes of the recording, good night, as this is evening. God bless and charge on.